To some questions.
Thank you very much for the opportunity to appear before this committee. I have provided a handout that hopefully you do have with you now.
Yes.
I won't talk about that in depth. I think it's best to see it as an information pack so that as questions are asked, there's information that's contained in that handout. One of the most important pieces of information is about our understanding and the industry's understanding of the way that the Section 38 section of the EPBC Act was always meant and does in fact operate. And that is that it provides a system through which the Commonwealth and the state agree that there is an alternative substituted accreditation of a system that is specifically designed to manage forests. And to preempt any questions that I might have about this, it is special. It's special because the management of forests is an activity that takes the efforts of both the Commonwealth and the state, and where there also are arguably overlapping obligations between the Commonwealth and the state. So the system that's been put in place is to provide clarity about which set of laws will operate. That system is meant to operate so that those people in the industry who are operating have absolute clarity about the law that they are meant to comply with. In the handout that I provided, I have included as the last page an example of the Leadbeater's possums in the actual fault case, because I believe that it's really appropriate to talk about what really happened in that case. There's a lot of speculation about it. We're probably just about the world's experts on the case. Ms Naylor is our legal counsel who has managed those cases for us. So I'll use the Leadbeater possum prescription as an example of what we would suggest is a perverse outcome from that case. In the case, the environmental group made inquiries to the state regulator about whether or not there are particular areas of the forest that we were harvesting in should be categorised as specially zoned as being excluded from harvesting on the basis that they were good habitat for Leadbeater's possums. The regulator looked at that part of the forest and said, no, it shouldn't be zoned in that way, it's available for timber harvesting. And we harvested those areas on the basis of that assurance from the regulator. We applied the specific and very detailed prescriptions that were set out by the regulator for the way that we would manage potential threats to Leadbeater's possums. The specific and detailed legislative obligation that we have in Victoria for managing Leadbeater's possums is that if there is a detection of any possum, there is a circle put at where that location is, and that means that that is an area where harvesting is excluded. And I have included in my handout a map at a detailed level in Warburton. Where you look at it, you will see lots of circles. So there are dots on that map, which are all areas that have been zoned as being areas where harvesting is excluded, because that is where a possum or possums were detected. And so the way that the system operates in Victoria is that that area can no longer be harvested. There is a buffer put around the tree or the area where that possum was detected, and we can harvest around it, but not in that zone. Notwithstanding that we had applied that prescription, which was the legal obligation that we were given by the Victorian government, the federal court determined that in her view, different steps should have been taken by us, and that because the judge believed that we should take different steps, her view was that we were breaching the code of practice, even though we were applying with the formal prescription set down by the Victorian government, and that in her view, therefore, we had breached the code. We had not been operating in accordance with an RFA, and therefore we no longer had the benefit of the alternative accredited regulatory regime set out by Section 38 of the EPBC Act. I would hope that you could see that as a matter of public policy, that is a perverse outcome. That could never have been the intention. We have just sat through 3 days of a federal court hearing where some of the greatest minds in Australia have grappled with this, and I will say this. Those judges made it clear that they consider that Section 38 is ambiguous. The judges spent hours of those court proceedings asking questions and making comments that made it clear that they consider that it's ambiguous. They also made it clear that the outcome where harvesting could be flipped out of a state regime into a federal regime because of an alleged breach of a code was perverse and unconscionable. So without preempting the outcome of that matter, because we are waiting for judgment in that, it is a matter of the transcript, and it was a public hearing, and so I'm simply reporting on the kinds of commentary that were from the judges in that case. To ensure that there's maximum time for questions, I'm going to stop there. They were the two matters that I wanted to really raise, but I'm happy to also talk about any of the other materials in that handout or any other matters.
Thank you, Ms Dawson. That's much appreciated. In that case, we have time to go to 10-minute blocks. So, Senator McKenzie, I will start with you for a 10-minute block, and then Senator Rice will come to you.
Well, thank you very much for a brief opening statement. We've heard mentioned the magnitude and the extensiveness of the environmental framework which forestry is conducted within Australia, and yet we continually have evidence to the contrary that we're, a nation that has poor environmental standards when it comes to managing our forestry estates. Can you give us a brief outline of the environmental framework that VicForests has to operate under to give assurance, if you like, to the naysayers?
So there are two acts in Victoria that lead to the creation of the code, which is under the Conservation Forests and Lands Act, and then we operate under the Sustainable Forest Timber Act. Under the Sustainable Forest Timber Act, we are required to comply with the code. The Code of Practice is a document which is 80 pages long and has very specific requirements about our obligations when we are conducting timber harvesting in Victoria's state forests. That is then supplemented by the Management Standards and Procedures, which is a manual of 198 pages, which is incorporated into the code, so it has the same effect. They are both legislative instruments because they are, by force of law, required to be complied with. The system that is in place for managing any allegations of breaches of those legislated obligations in Victoria is that the regulator can investigate, they can require us to provide any information that they need, they will conduct an audit or an inquiry into any allegations. In the event that any matter is upheld, they will provide directions to us, which could be directions to cease harvesting, so it could be a stop work direction. But ordinarily the directions that we received are in the order of could you build your snig track in a different area. So a snig track is the track that you build to pull the logs down. One of the areas where we've been working very hard to improve our practices is the gradient of the drains that we build to make sure water is draining properly. So they're the sorts of matters where we get directions. And to preempt a question that I'll get around audits, our audits are very good from the regulator. Independent audits are conducted on an annual basis, and we are right at the top end of our targets in that for most of our audit requirements, the target is 60 to 100%, and we're at 98%, 95%. So we do very well on our audits.
Well done. You're also implementing the work of one of our other witnesses today, Professor Lindenmayer, as part of your management practices?
That's correct. Professor Lindenmayer, quite a few years ago, I won't say that out of respect for him, but many years ago, Professor Lindenmayer did work for the timber industry and provided advice on the sorts of practices that should be used, particularly in the mountain ash forests of the Central Highlands. He recommended an approach which is retention harvesting. And so instead of a traditional clear fell operation where you take out all trees except seed trees, he recommended that you should create islands of trees and focus on retaining, in particular, those trees that provided the best possible opportunity for habitat by having hollows or that would in future become hollow-bearing trees, as well as creating islands so that the possums would be able to move around and be connected to the outside forest area. We have implemented that system. My understanding is that Professor Lindenmayer recommended that retention should be in the order of 15%. Our system that we implemented almost 2 years ago now sees the retention of between 20 and 80% of trees in a coop. That retention absolutely is based on the quality of the habitat. So the better quality habitat, the higher the retention. And so in many of the areas that are in the Central Highlands, we would be retaining on average about 50% of the trees in a coop to create that opportunity not only for current habitat, but also to support recolonisation and use of those forests in the future.
So I expect I'll be hearing really positive things from Professor Lindenmayer about VicForests operations.
Unfortunately, Professor Lindenmayer hasn't engaged with us about the practices that we've now implemented, but I'd certainly be hopeful that if he had the opportunity to look into what we're doing, he would see that it is fully consistent with his recommendations to the industry.
You raised the issue of ambiguity in your recent, in the 3 days just recently with eminent judges around what this bill is hoping to actually solve. In your view, will the amendment to the EPBC Act that we're investigating today resolve that ambiguity? And I also, will it actually resolve and clarify that ambiguity?
The conversation, and it's also with our QCs and other legal advisors that we've worked with obviously for an extended period of time, is that it is a reasonable interpretation that the phrase "in accordance with the RFA" is tautologous. That it is just gloss, that it doesn't add anything to the intent of the Act, because the Act was clearly about creating an alternative regime. And it is clear on the face of the RFA Act, the RFA agreement, the language in the agreement, the specific obligations in the agreement, that it is the formal intent and agreement of the Commonwealth and the state that any management of environmental matters in a forest area where there is an RFA is through the alternative regime established specifically for forests through the RFA process. And so one of the reasonable interpretations is that the phrase is tautologous. Of course, if it's tautologous, then it's meaningless, and then it could be excised from the Act without having an effect. Because, of course, the removal won't change our legal obligations. We're still bound by the RFA, we're still bound by the Code of Practice in Victoria and the legislation in Victoria. So on a day-to-day basis, the only change for me is that I wouldn't be worried about another federal court action being lodged next week on the back of the decision in Volk.
Thank you. So, I mean, another assertion that we've heard from some witnesses and submissions is that this amendment would dissolve the Commonwealth's oversight of this sort of process and approval of frameworks, etc. Could you just clarify what is the role of the Commonwealth?
So the Commonwealth, through the RFA, and I've alluded to this in my presentation, there are specific clauses of the agreement about how disputes are to be managed.
That's right.
And so in the event that the Commonwealth did have a concern that Victoria wasn't meeting its obligations, wasn't putting in place new prescriptions as new information about species came to hand, the Commonwealth has the capacity through the legal framework in the RFAs to raise that a dispute and to take action with the state of Victoria. To the best of my knowledge, there's been no dispute raised about the leadbeater possum prescriptions. And to the best of my knowledge, no dispute was raised about the fact that the state didn't disseminate a greater glide response in the timeframes that are ordinarily required.
On notice, I will ask you to respond to some of the critique around that RFAs represent weaker environmental protections for threatened species than the EPBC Act. But I just want to really draw you to what I found a really interesting additional submission was the AGS's submission to the federal court for the actual, where you were VicForests was the respondent and the Friends of Leadbeater Possum were the applicants. It makes quite clear here that from the Commonwealth's perspective, the RFA should stand and they're very much backing in VicForests' perspective. Do you note if there's been any change from the Commonwealth perspective post this submission?
I've certainly not had any contact from anyone from the Commonwealth for in excess of a year. Certainly a year ago when the decision was handed down, the Assistant Secretary that I had engaged with and had regular contact with during the case frankly expressed surprise and disappointment and shock at the decision because it was considered to be, as you have commented on, Senator McKenzie, inconsistent with the view of the Commonwealth. There were many people who were very surprised because, on one hand, it seemed pretty clear what was intended by the Parliament. Clearly, it's not clear because we wouldn't have spent in excess of $5.5 million on legal action on something that was clear.
That's right. So is this a case of an activist judge?
It wouldn't be appropriate for me to comment. I would say that the interpretation is in some respects novel.
It's very diplomatic.
It's probably a very good time